It's great to welcome today John Tai to the program, a former NSA whistleblower and a lawyer who back in 2017 founded Whistleblower Aid, which has provided support to the anonymous Ukraine whistleblower, among many other things. John, great to have you on today.
Thank you so much, David.
So let's start with your path. Executive Order 12333. What is it and how did that turn you into a whistleblower?
Thanks. I was at the State Department. I worked in the Human Rights Bureau from 2011 to 2014 on internet freedom. And in that role, I had a top secret clearance. So I was reading intelligence from various countries around the world. And in June of 2013, the Snowden disclosures became very public news. And I was part of the diplomatic response to those disclosures, both with Germany, Brazil, other countries, the United Nations, the Human Rights Council in Geneva. And during that period, in the 9 months following that, I got a couple of briefings from the NSA on the scope of U.S. signals intelligence collection. And what I learned was, for that whole year following the Snowden leaks, there hadn't been a single story, despite front page stories almost every day, hadn't been a single story on the main legal authority that the NSA is using to collect Americans' data, which is, as you said, Executive Order 12333. I was concerned about this. I was interested. I obviously care very deeply about human rights and Americans' privacy. And so basically, this is a legal loophole where the NSA is using an authority originally intended to collect foreigners' data to actually sweep up most of what we do online. Including U.S. persons, American citizens. This concerned me. It wasn't being addressed in the policy responses to the Snowden disclosures. And during that period, I became a whistleblower. I did not want to go to prison. I did not want to flee the country. And so I hired a couple of lawyers. I paid them $13,000. This would have been in 2014. Probably March, April 2014, and went through the lawful disclosure process. So I met with the State Department Inspector General, the NSA Inspector General, House and Senate Intelligence Committees, and others, and eventually went through the pre-publication review process and published an op-ed in the Washington Post about this problem.
So essentially, you believe that Order 12333 was being misused in order to surveil Americans when, as it was written, you believe it was not meant to apply to Americans.
Yeah, that's right. It was originally, before the internet, there were two legal regimes, a statutory regime for intelligence agency operations inside the United States, which is under FISA, the Foreign Intelligence Surveillance Act. And then 12333 was meant to cover all the operations outside of our borders. With the internet, that distinction between inside our borders and outside our borders became almost irrelevant, or much less relevant. And a whole bunch of Americans' data is stored in data centers around the world, and it's treated as foreign persons' data and collected as such by the NSA.
When we think about the government's treatment of prominent, and again, even the use of the term whistleblower versus leaker, it's the subject of debate and controversy. So I'm not trying to sort of like prime the discussion in any particular way. But when we think about the treatment of folks like Edward Snowden, Chelsea Manning, et cetera, you have a very wide range of opinion as to how these individuals should be treated. On one side, you have the idea that strictly speaking, if information was released in violation of how that information is classified, or if the information was obtained in a way that violates the law or whatever, that's essentially all that matters, that the content really doesn't, and individuals should be punished as such. On the other side, you have those who believe that these are merely heroic acts that should be celebrated and acted upon to change what is the misbehavior of the government, including, as you say, the misuse of an executive order in the case that you discuss. What is your general approach as to how individuals should be treated by the government and by the justice system?
Well, our motto at Whistleblower Aid is report government and corporate lawbreaking without breaking the law. So We are a legal organization. We would not never help anyone to leak classified information. With that said, these are very difficult questions. There aren't easy answers. And I think reasonable people can disagree on some of this stuff. We created this organization so that people wouldn't have to choose between following their conscience and avoiding harm to themselves. So we try to help people follow the available lawful disclosure process. There are often more options available than many people realize, and open up more options so that people can keep their careers, don't have to go to prison, and still try to inform the public about what's going wrong. With those cases you mentioned, those people didn't feel like they had other options, and we are here to try to help people not have to put their career or their freedom in jeopardy.
Not to be overly conspiratorial or dystopian or whatever, but one can imagine situations where one would believe that the information they are trying to disclose or what they are trying to blow the whistle on is so damaging to the government that going through the process you describe might put them in jeopardy, might put them in danger, might allow them maybe to be silenced. So is it at least theoretically conceivable that people could be in a position where they want to go the route that you help people go, but they believe that starting that process actually puts them at risk or may prevent the information from going public?
Yeah, absolutely. It's a risk. There's no easy things here. And the more important the disclosure, the more significant it is, the more risky it is for the individual. And there's no way around that. We're doing everything we can to minimize those risks. But the very first thing I tell people when they come to me is, look, the safest thing you can do is go home and never talk to anyone about this again. So, most people, by the time they get to me, they've crossed that bridge and they want to explore their options for going forward. But, it's risky, and I would never say otherwise.
Can you talk a little bit for folks in our audience who might be thinking about WikiLeaks and the way that WikiLeaks has been an intermediary with much information that have been released? Can you talk about how what you do is completely different than what WikiLeaks does?
Absolutely. We are not WikiLeaks. We do not help people leak classified information. We would never, help someone. Julian Assange has been accused of attempting to help someone to hack a government database. We would never help anyone try to do that. Look, that organization has been credibly accused of, working wittingly or unwittingly with Russian intelligence. We would never do anything like that. I swore an oath to the U.S. Constitution when I was at the State Department. I'm still bound by that oath and take that very seriously. So we are very different from that approach. With that said, I'll say I don't agree with all of the charges against Assange in the sense that, if the allegations are true, and I don't know the facts, it certainly would be illegal to try to help someone hack a government database. I think publishing things received from someone else is not illegal and should not be illegal. So it's a complicated legal matter.
When it comes to the Ukraine whistleblower, can you talk a little bit about, do you believe that, I mean, this is an individual who became the target of so many prominent people in the public eye in the lead up to Donald Trump's eventual impeachment, et cetera. From your perspective, what did they go through this process in the correct way?
Absolutely. So they immediately sought legal counsel. My colleague Andrew Buckeye and Mark Zaid were the lawyers for that, who are a part of our team here at Whistleblower Aid. From the very beginning, they were planning how to do this in a lawful way that would not expose the client to criminal prosecution or even dismissal from their job inside a U.S. intelligence agency. That person is still employed. They did follow all the rules. They are entitled to legal protections. I think they're an example of how the system, of how people do sometimes have more options than they know about. The legal processes here are very obscure. Some of these statutes haven't been tested very often, and so we saw that with the attempts to get this disclosure to Congress. It was bumpy. The White House did try to block Congress from receiving this in violation of the laws, but ultimately the lawyers, Andrew and Mark, were able to get it to Congress. So I certainly wouldn't say that our system is flawless, but there are often more options than people understand. And in this case, the client did an amazing job and is a true hero.
Were you able to, or let me phrase it a different way, before the attempts to out and create backlash against the whistleblower started, had you already anticipated that it would reach the degree that it did? And how did you advise the client to be prepared for that in terms of security, in terms of practical things?
Well, I have to be a little circumspect here. First of all, I never had any direct contact with the client. Andrew and Mark, my colleagues, were the ones representing the client.
Yeah, you as a
they
firm,
were in direct
I'm saying,
touch. Yeah, our firm. So I can't confirm or deny any kind of things about that person's identity or anything like that. Broadly speaking, as soon as it was clear that this implicated the president and the 2020 election,
yes,
it was obvious that this was going to be a very high-profile matter, that there were going to be security concerns. From day one, we brought in top-level security people on the digital side, on the physical side. As you may know, Mark Zaid, one of the lawyers, he was getting death threats. We had armed guards on Mark Zaid 24 hours a day for months. And now the Department of Justice is bringing a criminal prosecution against one of the individuals who was threatening to hurt Mark. So it was a very serious situation. We knew that from the beginning. And from the beginning, we were taking steps. That's really all I can say.
Is this, once you understand the scope of what is going on, and again, without revealing anything particular in general terms, do you do extra? I mean, I know that you say, you always say to a lot of the folks that come to you, the easiest thing for you is to go back home and never speak about this again. But are there more conversations than normal of that type, given these particular circumstances?
I was not, I never had a conversation with this client, so I'm not going to speak to that.
Fair enough. When we look going forward, is there anything that you believe took place in or surrounding the Ukraine whistleblower situation that may sort of change the way these things are potentially handled in the future, both by a firm like yours representing someone like this, but also the way that Congress, the House of Representatives, and others worked in receiving the information?
Yeah, clearly threats, intimidation, starting with the president of the United States, the president's family, senior officials, U.S. senators, attempts to identify, intimidate this person are extremely harmful, arguably illegal in some cases. You could make the argument that any kind of presidential effort to intimidate a whistleblower itself constitutes, an offense. And so there were serious problems here. Some of those people should be held accountable for their actions. It is never right to try to identify a whistleblower with the knowledge that, some extremists would threaten that person, possibly act violently against that person. There need to be stronger protections in place. Arguably, that kind of behavior should be criminalized, which it's not today, except in certain narrow circumstances. And, Congress needs to identify the gaps that were apparent in the system and fill them with legislation. And certainly there need to be reforms. Andrew and Mark published a New York Times op-ed 2 or 3 weeks ago that laid out some of their ideas for that. So clearly there's room for improvement.
Yes, certainly an understatement, I would say. Room for improvement for sure, as in regards to a lot of the elements of how this all went down. John Tye, former NSA whistleblower and attorney, who in 2017 founded Whistleblower Aid. John, so great to speak to you, and I really appreciate your time today.
Thanks, David.